Our next speaker is Chris Oprison. He was from Akerman in Washington, D.C. He concentrates on white-collar criminal defense and represents companies in government investigations, healthcare fraud, and lawsuits arising under the False Claims Act and Foreign Corrupt Practices Act. He has served as a presidential appointee. He was a former federal judicial clerk and a Marine Corps prosecutor. He was a special assistant and associate counsel to President George W. Bush. And in that position, he handled a variety of legal and legislative issues, including congressional oversight investigations, litigation implicating White House equities and interests, and nominations. And here to help us with some practical advice on how and when to fight back against the government and investigations and prosecution is Chris Oprison.
Thanks for having me here today. I did bring my kids with me, 3 of my oldest actually, and I just called up to the room and they're all still sleeping. So I had to check on them because last night my boys learned how to order movies, and so I just can't wait to see that bill come through. But I appreciate the opportunity to be here today. When DOJ comes knocking, can be one of the most unsettling experiences a client can have. They either get a call from the Department of Justice, they get a subpoena, or they get simply a letter of inquiry. And it could be civil or criminal. So what do you do when you get a call, an officious call from a well-intentioned DOJ attorney saying, I just want to ask a few questions, we want to come in and look at your records, you're not in trouble, we're investigating something else, can you help us out here? Most clients that we deal with know how to handle this. Some don't. Some overreact, some do exactly what you see in this. They go hit the john, or they throw up their lunch. What you can do is come in and I'm going to go fast. That's my buy Coca-Cola snapshot screen there. You can come and contract and talk with attorneys from the network. But you have to get an attorney, and Kevin was talking about it earlier in his presentation. You got to be smart about it. You got to act quickly. A lot of times, and I'll talk civil and criminal investigations and what to do in those situations, but a lot of times you don't have a lot of time to react until you get lawyers involved, and then we can put a buffer zone between the client and the Department of Justice or whatever federal agency is coming calling. But you have to stay flexible. This is the best I could do with this graphic here, but it's a Stretch Armstrong, which I had when I was a kid, and however much I tried, I couldn't cut him open and figure out what was inside. But you got to stay flexible throughout the entire process, as lawyers and as clients. And what does that mean? It means that you have to be able to identify what the issues are, but not get yourself on a linear track. We've heard that before. You got to be able to identify and recognize where you might be able to gain some incremental advantages along the way. Go on the offensive and take the fight to the government. There's time to kick in doors and there's time to knock on doors. In criminal investigations, you have to use a different side of your brain than in a civil investigation. That goes without saying. You know, there's so much at stake in a criminal investigation. Does that mean there's not a lot at stake in a civil? No. And in fact, we're often leery about civil investigations that are characterized as only civil investigations because there's always the opportunity along the way for the client to do something or evidence to come out where all of a sudden it takes on a parallel criminal investigation. So you have to be careful. When I say take the fight to the government, it's turning it around. It's creating an approach to the litigation, an approach to the investigation that puts you more in control. That's what you want to do from the very outset. Clients come, they want lawyers to come in. The first thing you do is you build the bridge to the Department of Justice. You let them know who you are. You're going to be reasonable, you're going to be good corporate citizens, but they're not going to be able to abuse your client along the way, whether it's civil or criminal. They've got to understand that. And you make that very clear from the outset. A couple of other things that you can do that you don't want to do. You don't want to be Rambo. And again, scorched earth works sometimes, but not all the time. And particularly in criminal investigations, you can really poison the well early in the process where you don't want to do that. There's time to build bridges. We'll talk later. When it does get to the point where either your client is sued by the federal government or you've got a grand jury subpoena and they actually charge your client as a target of the investigation, well, then the gloves are off. All bets are off. and then you hope that you've created the predicates along the way in the investigation to benefit your client as you're heading into trial. So we're the network of trial law firms, but all along the way, you've been hearing folks talk about how to put down markers, how to advantage your client, how to put them in the best possible position you can if it does get to trial, because that's what we do. But you don't want to go into trial without having these predicates down, without putting these markers out there, without holding the government's feet to the fire. I'm going to talk about civil investigations first and then criminal investigation. Now, Kevin Baumgartner talked earlier about whistleblower investigations. I handle a lot of whistleblower investigations. There's nothing civil about these cases. In fact, they get pretty nasty along the way. And, you know, the balance of power is always decidedly in the government's favor. That can change. We can move that marker a little bit. And, you know, Senator Grassley has been crusading against Medicare fraud and any other government fraud for years. And I'm personally of the view that he's made more millionaires out of bottom feeder employees than anybody in history. But the fact of the matter is that Senator Grassley has, every time there's an advantage that defense counsel get along the way, he changes it. He proposes legislation. He screws us up. So we create precedent, and then he goes and changes it. But you know what? There are still things along the way that we can do. And again, this is in the category of laying down the markers early and making sure that you're creating a tone where you're going to be cooperative, but also taking control of the investigation. Government sends you a letter and they say, produce all these documents by tomorrow. We want to talk with your employees. What do you do? And by the way, if you destroy documents, you'll be guilty of obstruction of justice. Well, that's fine. No client ever destroys documents, so we know that's not going to happen. So what we want to do is we want to make sure we reach out to the client. We say, put a lit hold in place. You know, if you haven't already done it, put a freeze in place for all the documents. The next thing you want to do is you want to probably go in and do some investigations internally. That's internal prophylactics. Externally, what you want to do is you want to turn around at DOJ, you want to reach out to the attorneys, and you want to say, are you preserving your documents? Are you talking, because this is obviously a whistleblower action. They may not admit to you that there's a key TAM relator at the outset, but you know there is. If they're investigating healthcare fraud, Department of Defense, fraud under the FARs, you know that there's likely to be a whistleblower. And it's somebody who, if there's a whistleblower, you know they've taken documents. And if they've taken documents, you know they've taken privileged documents. So we'll get to that in a second. But there's ways to set down the markers early when you talk to the Department of Justice attorneys and say, what have you done to preserve your documents? If this is a CMS investigation, you've got the IG's office involved from HHS, what have you done to preserve the investigators' documents, the CMS officials that are doing the Medicare, that are taking in the claims, that are setting the policy, that may be talking about this kind of case? What have you done? And one thing we can do, and we've done this before in cases, is we filed a Rule 27 petition. In key TAM cases are an interesting thing. You're named in a complaint, your name's in the caption of a complaint, yet you're not really a party. So you have no standing to bring any kind of action against the government or the key TAM relator. Well, what you can do is you can create or file a miscellaneous action for Rule 27 relief. And Rule 27 of the federal rules basically says, if you believe that there may be spoliation of evidence, whether it's from the Department of Justice or a state agency or Medicaid agency, in this case where we were working with an investigation in the District of New Mexico, and we had the New Mexico Medicaid division involved. And we, in our own due diligence, we went out and asked them. We said, what are you doing to preserve these documents? We said, we're following our FOIA laws. Well, that's not good enough. We have litigation impending right now. You need to make sure you're preserving all of these claims. And they weren't going to do it. So we filed an action early on, before the government ever said they were going to intervene. And we had an order from a court that basically ordered this state agency that wasn't a party to the action. They were just going to be sort of the material witness to the government's case, and had a judge order them to preserve all relevant documents. Had it very well specified. Now, that mattered fast forward 3 years later when we had to go seek sanctions against the Human Services Department because we found out they were still destroying documents and hadn't produced everything. And we were able to get a judge to order, that same judge, who, by the way, they don't like when anybody, agencies or individuals, don't pay attention to their orders, amazingly, and this one basically thumbed their nose at it. So we had the judge order them to engage a forensic investigator to go in and look at all their documents and pull. Wouldn't you know it, we ended up getting a tranche of about 10,000 new emails, and some of them were pretty incriminating. including the former secretary of the state agency, saying, let's just try to keep this under wraps. I don't have the quote up here, but let's keep this under wraps and make sure CMS doesn't find out what we're doing with these hospitals. Because if they do, they're going to point the finger at us. So that ended up giving us some relief and getting us an incremental advantage. And in front of that judge, educated the judge as to what our theory of the case was. So all of this creates a cascading effect. And you want to do it in the case where you think there might be somebody, and Rule 27 petitions are important if there's somebody dying, evidence is going to be deployed or moved, or if somebody's actually just shredding documents. The other thing you can do is you can request an early unsealing of the complaint. And what does that mean? Everybody knows when in False Claims Act investigations, the complaint is sealed for a period of time. By the time you learn about it, the government's already done 6 months to a year or more of investigating. They're way ahead of the curve. So what do you want to do? You want to find out what they've alleged. You want to find out what this employee or former employee has alleged against your company. You want to ask for them to unseal the complaint so that you know what this person has alleged against you. You know, maybe find out who the whistleblower is. Ensure that, one, nobody's retaliating against them if they're still an employee. Or two, you know where to look for the evidence. Who's downloaded all the documents the day before the guy was fired? You know, what documents are missing? And then you know the circle of individuals that person may have been communicating with. That may be where you want to start your investigation internally. And you also want to make sure you're pulling all the emails. That helps narrow it down. And you can start trying to undermine the credibility of that witness. The other thing DOJ must do is set up a taint team. So the first thing we did when we talked with the investigators in one of our cases, we said, so what have you done to preserve or to ensure that the investigating team hasn't looked at our privileged documents? Because we know 100 times out of 100 times that a whistleblower who takes documents takes privileged documents. Those are the best kind. And the DOJ attorney said, we've done everything we need to do, we fulfilled it. Well, they hadn't. They hadn't. And part of the process is, when you're in these civil investigations, is divide and conquer, right? So you want to convince in the investigative phase, you want to convince the DOJ that this whistleblower is just too much trouble. Either they don't have a valid case, their allegations aren't true, they're subject to impeachment, or they've somehow engaged in some sort of misconduct the government just doesn't want to deal with. All of that, when it comes time to calling balls and strikes, the DOJ has to decide if they want to intervene in a case, all of that matters. So you want to make sure they've set up a taint team, and that they've abided by it. You demand the return of the privileged documents from your former employee. Here we had a key tam relator counsel who essentially told us that when we asked him the first time, government decided not to intervene, we got him on the phone, we asked him, how many privileged documents does your guy have? And actually in this case there were two key tam relators. He said, well, how do you define privileged? We're like, how do you define privileged? You're a member of this California bar. So how many do they have? Well, we don't agree that every attorney-client communication is privileged. Okay, well, that's fine. Give us all back and we can make that assessment on our own. Ended up, they took more than 800 privileged documents and 5,000 documents this woman had downloaded on the day she was fired. 800 privileged documents we got back as a result of a year fight to try to get our documents back. And then, of course, we sought sanctions. In this one case where we had in the District of New Mexico, we also found out DOJ had failed, despite my well-framed letter early on before intervention, asking them to hold their documents because they were telling us to hold ours, that they had allowed 2 senior CMS officials' documents to be purged when they left. And we had a 2-day hearing in front of the judge. And their argument was, well, we didn't think we had an obligation to hold these documents until we decided to intervene. And, oh, by the way, they weren't relevant to our case, to which the judge said, well, what about when you made that $62 million demand for payment a year before and they told you to pound sand? Didn't you think that litigation was imminent at that point? And, oh, by the way, there's 2 sides to litigation. So what's relevant to your case or not relevant to your case may be relevant to the other side. So we ended up getting $500,000 in fees on Christmas Eve and a check paid to our client to recover for the cost of having to bring that motion. And we got their privileged documents. Again, DOJ's privileged communications between them and CMS officials revealed quite a bit. And in one case, we actually get a voluntary dismissal because we threatened sanctions against one of the key tam relator counsels when his client had taken a privileged board memo that was provided by outside counsel as a result of an internal investigation. His client was the former CEO. He had access to it during the normal course of business, but when he left, he took it with him. We found out about it, and we threatened the sanctions and threatened to get it back, and they ended up voluntarily dismissing our client from the case. So those are good results. And again, setting the markers, setting the groundwork early on. Criminal investigation's different, right? All bets are off. You got to be careful. But you still can take some measure of control, right? Protecting your client, putting a buffer between them and the Department of Justice, the assistant U.S. attorneys. And we always assume going into our civil cases, always, that there's going to be a criminal piece to it. Always assume it. Because, yeah, and we ask early on, is there a criminal component to this? No. Well, then why do you have two investigators from the Defense Criminal Investigative Service on the phone with us, and they're part of this investigation? You're telling us that, and we want assurances. They won't ever tell you for sure because civil doesn't speak for criminal, criminal doesn't speak for civil. But you can kind of guess along the way that there may be a criminal piece to it, or that it could develop into a criminal investigation. That's happened more times than not with our, some of our device clients and others, that there may be a rogue individual out there that you need to be aware of that is engaging in conduct that could be considered criminal. My old boss, Bob Bennett, used to tell us, and this was good advice, whatever you do, don't flunk the investigation. Oops, right? So Bill Clinton gives a deposition in our old office, my former firm, and in the Paula Jones case, and that's where he said, that he's never had a sexual relation with Miss Lewinsky. That was a different time than when he got up at the press conference, but denied that he ever had a sexual relationship with her. That was not true, and from those false statements during the course of that deposition, he was ultimately impeached. Now, I will tell you as a side note, we know which chair he sat in, so whenever we did depositions in there, somebody marked it with an X, and I just kind of moved. I thought that was bad mojo to have somebody sitting in the same seat the president was sitting in and lying. But the bottom line is, the message is don't flunk the investigation. So what do you do? How do you make sure you're not flunking the investigation? Because it's not always intentional. In this case, I think it probably was. But in other cases, there may be people that are getting out ahead of the facts. Okay, they're talking too quickly, and I've got good examples on that. I'll get to in just a second. So what do you do to protect your client early on? They get a subpoena. You want to negotiate some deadlines. You want to seek alternative forms. Somebody is a witness in a grand jury investigation. We had a client who was just a witness in the Bob McDonnell case. Was a member of the House of Delegates in Virginia who had been friends with Governor McDonnell. He came to us and said, listen, I want to talk. I got a subpoena. I want to go talk to the grand jury. I said, no, you don't. You don't want to talk to him. Let me try to get you an interview. I said, I won't be in the room with you, first of all. And second of all, you don't have anything to prove. He said, I want my name to be clear. I said, you're not named in this. I said, don't be silly. You can't do that. It's a bad choice. He ended up, we negotiated. He had a 2-hour interview with the assistant U.S. attorney, never testified at trial, never got his name in the paper, which politicians tend to like to do, whether it's good or bad press. But ultimately, he got away, and it didn't get away. Excuse me, I wouldn't say that. But he got off without having to testify at either the grand jury or the trial. It's one thing to be helpful, want to cooperate, and I couldn't think of anything better right here. Cooperation is key. Being helpful is risky. Ask this guy, Zach Warren, who's the former client relations manager, Dewey LaBeouf. Met multiple times with Pierce Moser in the course of the investigation of Dewey LaBeouf's implosion. And what is he now? He's one of 4 that's now indicted. Why? Because he sat down without counsel, smart kid, went to Georgetown, clerked on the 6th Circuit, had a job at Williams and Conley. Life is over. He's now named in a criminal indictment. My former peeps from the Department of Justice. So this was a time I was brought in, and these folks got ahead of us on the U.S. attorney firing scandal. I came in, was handling that investigation for the White House, and meantime, as we're trying to compile the evidence and trying to figure out what happened, these guys are going and talking behind closed doors with Chuck Schumer, giving that, and I would say it was Paul McNulty and Al Gonzalez. Why? We have no idea. Got ahead of the facts, weren't prepared, had to go multiple times, ended up being a perjury investigation. Hell, I got investigated and deposed. You're never part of really the team until you're there. They got you in the crosshairs. But we can all laugh about that now. But the fact of the matter is that this was a bad way to handle it, and this was handled by DOJ in that case. So what do? You just be smart about this. There's also this 1001. Denying everything isn't always the best thing to do. Obviously, just ask Barry Bonds, right? I mean, there is a potential obstruction charge that goes along with it. And I just had to get a My Cousin Vinny photo in here, which I think is one of the best lawyering movies ever. And I've often wanted to do an opening statement like this, but restrain myself. But just holding the government's feet to the fire. That's what you got to do. You got to hold the government's feet to the fire, make them understand they've got obligations as well, whether it's criminal or civil cases. I thank you for your time. I see my boys are in here, so there's no ordering any movies in the room at this point, so we're good to go. Thanks for your time, folks.